I just want to say welcome to everyone. I know we have a we have a large group of real estate agents that have signed up for this. So it just tells me that it's a topic that really resonates and that people are interested with. I think we had almost 200 that registered. So thank you for taking time. I know your time is valuable. And so we really, really are grateful that you carved out this time. I want to first say, most of you have come by way of one of our great salespeople and account executives and our director of sales, Carmen Carbonara, inviting you here. And so I just want to first off, introduce them on the panel, or on the, they're panelists. But today we have Carmen Carbonara, we have Denise Hellstrom, Anya Pullet, Andrew Rudich, Dominic Floro. Really that's the channel that everyone can work with Land Trust through, are these great professionals that are in the marketplace every single day, connecting agents to attorneys and just being a resource for you overall. So welcome everyone, our reps, and thank you for your hard work. We're really pleased to have, we had in the fall, we had our 1031 exchange program, which was so well received. And we also had a great session on blockchain and crypto and how that integrates with real estate. And if you missed that and you're interested in, still having that information, you can reach out to your rep and get that. So there's that. And then we also, before I introduce our speakers, we have some great real estate attorneys that have offered up their expertise to be panelists here. And we have Ray Santowski. Ray, welcome and thank you for being here. We have Mike Angelieri. Michael, thank you very much for taking time out and being here. And then we have Ryan Waite. And so Ryan, thank you for being a resource. And all of these professionals, and I think we're going to have Chuck Saragusa on, but I didn't see him in yet. If he's in, we'll have him chip in as well. But all of these professionals are here because they have a great amount of experience in some of these areas that we're covering. And so we'll integrate them into the conversation as we go. So finally, I'd like to introduce our speakers. We hosted a fantastic continuing legal education event for our partner attorneys in the fall, where we had Eric Anderson and Scott Lascari come out and talk about foreclosures and tax sales. And it was really captivating. And there was a lot of engagement. And I thought, wow, we should really try to package this so that it could be a resource for our great real estate agents that we work with, and just agents in the real estate community. So I want to introduce Eric and Scott. Eric and Scott are from our partner underwriters, Fidelity. And Land Trust has had a great partnership with them. We're ranked number 10 out of 1,020 title agencies in the Midwest and the Mid-South with them. And we're 57th out of the 5,300 national partnerships that they have. And so it just is, speaks to the partnership we had and the resource that we have in them. And so from Land Trust to them, back to you, and to your buyers and sellers. So it's our honor to be able to provide this for you. And so without further ado, I'm going to turn it over to Eric and Scott. And if you have questions during this, during our presentation, please just pop it into the Q&A, or if you want to raise your hand, that's fine as well. But just use that Q&A chat box to be able to ask the questions that you need to ask. So without further ado, Eric and Scott, why don't we kick it off, foreclosures and tax sales, and then I'll be bringing in our panelists as we go on. Thank you.
All right. Well, thanks, Steve. And first of all, the one thing I'll say is Steve introduced us as speakers, but we really look at this as a discussion. Steve mentioned that we came and we spoke to attorneys this past fall, and we really dug into the details of this. What happens in the courts, what you need to ensure a transaction, but we know that's not our audience today. We're really going to give these two topics a very high level treatment, and it's really just to give you a sense of what goes on as you approach these types of transactions, what might slow them down, what might be the challenges. So feel free, and we really encourage a discussion from the attorneys that are on here, from the people at Land Trust, but also certainly from our audience, the realtors. So where we're going to start is with foreclosure proceedings. And it's kind of funny. I was talking to my 15-year-old daughter yesterday, and she was talking about this, and she's like, so you're making a presentation to realtors and you're talking about what? And I said, well, foreclosures. And she's like, what is that? So I thought that's really a good place to start. What is a foreclosure, or how do you get there? So you're never going to see a foreclosure when you have someone who buys property for cash. Okay. Where you're going to see it is when you have a lender. People need to borrow. Most people are going to borrow money. Maybe they need to, maybe they just want to, but they're going to borrow money to buy property. And when they do that, the lender asks people to sign two things that influence what we're talking about today. So they ask people to sign a note. A note is a personal obligation. It's saying, I promise you, it's an IOU. I promise to pay you a certain amount of money over a certain time. You're going to charge so much interest, etc. So that's the personal debt that a borrower will sign, but that's not good enough for a lender. Because the problem is, if you don't pay your mortgage, how are you going to, or if you can't pay that note, what recourse does the lender have? You can't get too much lemonade out of a lemon, or you can't squeeze an onion too much. So what the lender also asks borrowers to do is sign a mortgage. And a mortgage is security for the lender. It is a lien that is then placed on the property that's being purchased, and it allows the lender to have certain rights should that note and mortgage go into default. And when we're talking foreclosure, that's what we mean. It's gone into default. Borrowers have not been able to pay the mortgage for whatever reason, loss of job, change in circumstances, etc. So that's where we start. There's a note and there's a mortgage. And really, from a title perspective, we don't much care about the note because that's a personal obligation. But what we do care about is that mortgage, because that mortgage becomes a lien on the property. And it's what allows a lender to actually take away title from the borrower and transfer it to someone else. So that's where we start with foreclosures. So a foreclosure is a suit by the lender to repossess the property because of a default in payments or other terms of the mortgage. As I said, it can result in a loss of title, but just because a foreclosure has been filed doesn't mean it's all over for the borrower. The first step really is there's a right of redemption. Oh, if you miss 3 payments or you're 3 months late and the lender begins a foreclosure, you still have a right to redeem. The borrower can make up those payments. But if they can't redeem, then we go through a lawsuit. It's in civil court, and it's a lawsuit filed by the lender. And the big thing is, when they are prosecuting that lawsuit, they have to give what we in the legal field call due process.
Hey, Scott, I want to stop you right there.
Go ahead.
So does it have to be 3 payments? Is it always 3 payments?
No, it's not always 3 payments. I would say 3 payments is how people generally think about it, how lenders will approach it. But during the pandemic, for example, we had forbearance laws that were passed out there, where borrowers could choose not to pay down the principal. They would make a lesser payment or not make a payment at all. And what it did is it didn't change what was owed. So they weren't paying the principal, and it was just adding on time and adding on payments later. So they could have gone 6 months, they could have gone a year during that time for sure, because they got a forbearance agreement with the lender. And that's the big thing. When you have a borrower who's in default, the best thing that they can do if they want to keep that house is reach out to the lender. You know, if you don't make the payments and you don't say anything to them, that's where you're going to get into this foreclosure situation.
Yeah. So that when you say a borrower's in default, how soon is it, are they in default? When they're 30 days late, when they're 60 days late?
Well, and that's going to depend upon the note and the mortgage, right?
Okay,
So when I have my mortgage, my payment's due on the first of the month. Can they give you a 5-day grace period? So if I don't get it in on the first, but I get it in on the 5th, it's still within time. I think my mortgage, if I'm past the 15th, that payment is in default. You've missed that payment, and now you're going to be late, and you're going to be charged late payments, etc. And think about it, a lender does not want that to go on for a long period of time. And that's why we get into foreclosure. You don't pay 3 months, you don't pay 6 months. Well, the lender's not getting their money. Now they have to seek recourse.
okay.
So what we're talking about is due process in a case. So when a lender files a case, they're called the plaintiff, and the people who are defending against that case are called the defendants. So the plaintiff is the lender. The defendants are the ones who are the borrowers or other people who have some interest in the property. They might have a mechanics lien. There might be a tenant. Other people who have an interest in the property, they all have to be notified about the foreclosure. And the big thing that we look for when insuring it is due process. And I would separate due process into 2 elements. One is notice. You're not going to defend against a foreclosure unless you know about it. So the foreclosure laws are written and they're prosecuted in a way that anyone who has an interest in the property has to get notice of that foreclosure. You're aware that the property is in a foreclosure lawsuit. And the second part of due process is an opportunity to be heard. So if I'm a borrower, I go in default, my lender sues to foreclose on my property, I have to get notice of it. And it's not just, hey, Scott, guess what? We're taking your house tomorrow. No, it's, hey, Scott, you've been sued. We're suing you for foreclosure. Now you have your opportunity to come into court and be heard. And this is kind of when Steve asked that question, when do you go in default? Well, it's better for a borrower to talk to the lender before this happens. But even when this happens, that borrower can still talk to the lender and try to work this out. And whether the lender will or will not, I mean, that's obviously between the parties to that mortgage.
Okay, Scott, 1 second. So
Yeah.
guys, Mike, do you have people come to you at this stage of the game where they're, 60 days behind, they don't know what to do, they're afraid? Do you get those calls?
So, unfortunately we do, but usually not until much later in the process. What I think happens is people sort of on these foreclosures. I've been doing short sales and foreclosure work since 2005. And it's sort of come and gone here over the years, right? There haven't been very many short sales or foreclosures in the last 7 years, but what they're coming back though, and what we're finding is people are calling us when maybe it's not too late, but it's a little bit later in the game than what we would ideally choose. So kind of to your point, you start the discussion with the lender before they file the lawsuit. Maybe you're in default if you're 15 days behind, but there's several months usually between the day you miss your payment and the day that they file. If you have a smart homeowner, or I should say an informed homeowner, starting the process of discussion with the lender right away is a good idea. What we're finding is they're coming to us a month or 2 or 3 after they've been served with the paperwork. And there is still plenty of time to do it. But what we see is the level of panic from these homeowners is a little bit higher than what's probably good for anybody's health. So the best bet is get these people in touch with, their attorneys, the real estate agents who use go-to attorneys that know something about foreclosures. Getting in touch with the attorneys is key because, as the panelist Scott sort of pointing out here, it doesn't mean the game's over if they file the lawsuit. There's still plenty of time to get the house sold, get the loan reinstated. But for us, we would just tell people reach out as early as possible so that we have enough time to figure out the right solution.
Great. Ryan, wait, anything to add to that from a standpoint of partnership with agents? and how you can be a resource to them on this.
No, I think Mike hit it on the head there. It's important to get out in front of it early on. The more you kick the ball down the road, so to say, the harder it is to really negotiate a fair term at the bank. Because as Scott hit on, you miss 3, 4, 5, 6 months of payments consecutively, it's going to be very difficult to go ahead and negotiate a term to either sell that property before it gets into a short sale, or to even get caught up in the loan. So timing's huge and crucial there.
Okay, great. Ray, I just want to, anything to add to that?
Not much, just like when people sometimes call me, they say they want something, say, for example, like a quitclaim deed. And that's not a very expensive venture, but I tell them, it's not so much about the document or what I can do, but it's like, you want to solve the problem. And so I think if people come to you and say, they're in foreclosure, what can, they want to sell their house. Well, maybe they need to sell it, maybe they don't. And I think it's good advice to help them to figure out what the options are and where to go. Because even if they don't sell it now, they may remember you, that you helped them, and in the future, it'll bring business.
Great. Okay, thank you. Scott, continue, please. And again, if we have any questions, please pop them in the chat.
Well, and I just want to stress that point a little bit more. I mean, one of the differences that you'll see, if you can negotiate with the lender before they file suit versus after, once they file suit, there's going to be additional expenses that they're going to add on to that redemption. Now they've hired an attorney. Now they've had to file things in court, and they're going to do, filings and make motions, and that's all going to be added to your loan. So on Mike's point, get to them sooner. That's another reason to do it. An informed consumer, hey, you're in default. Your financial situation. You're going to be in trouble. Reach out as soon as you can and get some help. And before I talk a little bit more about foreclosures, I just want to point out, I've talked about mortgages, but the Illinois mortgage foreclosure law also handles the ability for a creditor to foreclose other types of liens. For example, if you have a civil judgment against you, or you had work and a mechanic files a mechanic's lien against you, these same concepts would apply. They can foreclose that lien, and they can try to take away title to your property. So
how often okay, I just heard you say a contractor does work, he does $30,000 worth of work, builds a garage, does your deck, whatever. How often do they actually foreclose? Does that happen often?
Well, how often do they not get paid? What Michael talked about, you haven't had the foreclosures for a while, and really contractors and lenders and judgment creditors to some extent, they follow the market. So the market we've had the past couple of years, everybody's getting paid. Loans are going out to consumers. If work is being done, it's being paid. You don't have that problem. But when you have the downturn in the market and properties aren't going for as much, and people lose their jobs or interest rates get higher, now a consumer is going to have to pick and choose who they're going to pay. And they can choose to pay their lender, their mortgage, and not choose to pay that contractor, but then the contractor has a debt, and they have that protection under the law. And I think as we see the market turn, you're going to see that more often. Now, what generally happens in my experience as a litigator in these courts, when you're not paying a contractor, you're also not paying your lender. And so what generally happens is you're going to have them both foreclose. They're both going to be involved in the same lawsuit as different people who want the money. But it can be initiated by a contractor and the lender joins in. It could be started by the lender and the contractor gets in. But it is something that, a lender might not pursue it if it's $10,000, but it depends on what kind of contractor you are. $30,000, $50,000, you did $500,000 worth of work. Yeah, they're going to pursue that remedy. And we have seen that in the past.
Great. Thank you.
And Steve, really quick before we move on, Scott, that was important what you said there. But when you bring up the Illinois Mortgage Foreclosure Act, the burden of proof is on the plaintiff. And I think that's crucial. And if certain people don't want to be out of their home right away, there's something called foreclosure defense. And there are there are many of options for borrowers within that can save some time and maybe work out a negotiated exit strategy. So keep that in mind. Just because there's a suit filed doesn't mean that the clock really starts ticking and it's a quick exit. It's if you find a decent attorney that knows the statute, there can be some options for the borrower.
Yeah, and just so we're clear on this, because for those of you who haven't watched Judge Judy, the plaintiff is the bank, right? In this case, or the contractor. Is that right?
Correct.
Right.
Yes. Thank you.
And then the defendants are the borrowers or people who have an interest in the property.
Thank you. Great. So the burden of proof is on the plaintiff. So it's
Absolutely.
not like, oh my gosh, they filed this and that, I need to move out tomorrow. You have rights, and that's why you need the team of professionals.
Well, right. And that's why we talked about due process. I mean, that is a big thing that plaintiff, that lender is going to have to do. And there are a number of documents which they're going to have to file. And as was just talked about, unless you consent, unless you agree, a foreclosure is going to go beyond 6 months. It's going to take time to get through the complaint that's filed, which starts the whole case. The summons where people are served with process, they're giving that notice. And after they get that notice, there has to be a time, then opportunity to appear, to defend. If they don't appear, or if they appear, there's going to be motions that are filed. And all of that, presuming that the lender meets their burden of proof. And what that is, it's a legal term saying they have to prove their case. They have to prove that they gave the money. They have to prove that you agreed to pay them back and that you're in default. And assuming they meet that burden of proof, and I'm talking very generally, I'm not talking to attorneys who are digging into the details of this. Assuming they do that, they have to get to what's called an order of foreclosure. But even when they get an order of foreclosure, it's not done because there are steps after that. It's going to go to sale. There is a process where if you open up the Chicago Tribune online or in paper, you're going to see all these take notices because properties are in foreclosure. Well, there has to be an amount of time. If the borrower is not going to buy that property, the lender wants to maximize what they're going to receive for that property. And one of the ways they do that is by making it a public sale. So they advertise, they publish. So there's time built in there between even the order of foreclosure and when the actual sale happens. Now, if you get through that process and the lender has conducted the sale, there's a judicial sale and that's completed, now you're really at the end of your time. There really isn't a lot much more time because then the lender just has to go into court, tell the court that the sale has occurred, get an order confirming the sale, and then there's a deed. There's a deed from the sheriff to the lender or to the new buyer. And now that borrower is out of title. So,
okay, so I want to pause you there.
Go
So
ahead.
guys, attorneys, so if you have a listing or if you're working with, if these agents are working with a seller and they're in this period of time where Scott says there's not much more to do, is there more to do?
Well, I would like to just chime in with kind of a general rule of thumb for the realtors. Okay, so the realtors on this seminar here, if you can get your property listed and an offer on your house at least 30 days prior to the sheriff's sale, and just kind of go over the terms again, as Scott mentioned, there's an order that a judgment's going to be entered and an order of foreclosure that's going to be entered. And after that point, it's generally 90 days after, they're going to set it up, schedule it for an actual sheriff's sale. Once the sheriff's sale happens, and the other attorneys may have a different experience with this on the panel, but generally speaking, once a sheriff's sale occurs, it's pretty much game over. I've done about 12 or 1,300 short sales, and literally only one time after a sheriff's sale happened were we actually able to revitalize the transaction and close. So as a general rule of thumb, what I tell the realtors, because they always want to know, like, if I'm going to list this property, is it worthwhile? Is it too late? I don't want to waste my time, the homeowner's time. We could go to a plan B. But if you're going to list a property for sale, if that's what the homeowner wants to do, at least we need a contract at least 30 days prior to the sheriff's auction to have a fighter's chance to get it done. Because generally speaking, if we're 4 days before the sheriff's sale, which is pretty much the do or die date, the negotiators are going to usually reject the file and say, we don't have enough time. Now, over the last 15 years, I've been in court asking a judge for more time. And in certain counties, they'll actually give it to you, maybe postpone the sheriff's sale 45 days or so. And then you go back to the negotiators and say, hey, guess what? The sheriff's sales got pushed back 45 days. Now we've got our 30 days required to start negotiations. And they'll do it sometimes, but not always. And it also depends on what county you're in. So if you have a listing opportunity at any time prior to the judgment being entered, that's a slam dunk. Let's take it and let's go. We just want to make sure we have a buyer and an offer at least 30 days prior to the sheriff's auction. That's our kind of general rule of thumb.
Thank you, Mike. And there's a couple of questions in the chat. And one of them is, do we have a chart for the process? And so what we'll do is after this session, we'll send you guys the chart and kind of the timeline of it. Another agent asks, how would an agent know when the 30 days would be? And maybe Ryan, you could handle that.
Oh, you'll have notice through the court, and on, just to piggyback off of what Mike said, obviously what we keep reiterating is time, right? The more time, the merrier for these things. But even don't be scared to list something a few weeks in advance, or if you know a potential buyer, if you get a contract like Mike hit on, an attorney that knows the foreclosure law can file an emergency motion to stay that sale. And like Mike said, most judges want to see that through. They want to give the borrower an opportunity to go ahead and attempt to have the closing. So don't be scared. I think, just because you're running, low in time here, reach out to an attorney. And if he or she knows what they're doing, they can buy you that time. But Steve, just to go back, yeah, you're going to have a notice of when that order was entered. And usually that day, the 30-day toll starts kicking at that point, the date that the order is entered.
Great. And what's the notification of the sheriff's sale? How do we know when it goes to sheriff's sale? That's another question in the chat.
Well,
Right?
Go ahead.
go ahead, Mike.
Go
Well,
ahead,
I was going to say the easiest and best way is this: the homeowner will get that notice, and the best way to figure that out is ask the homeowner what paperwork they've received. We could go online though and check and scour the sheriff's sale dates and everything like that. But it's not in my experience, it's not 100% foolproof way if we're just checking there. So then the other piece is, as long as we have a court case number, we'll call the plaintiff's attorney. In this case, it's a lot of times Cadillus and Associates. You guys have probably heard of. They're doing a vast majority of these foreclosures here in the Collier counties. So the client's the best way to let you know if they get notice. But also, if we have a short sale pending, if we're negotiating a short sale, believe me, we'll check once or twice a week online. And then also, if we think a sheriff's sale is coming, the plaintiff's lawyer will freely tell you if you call them.
Great. Thank you. So one other question that we have is, if a file has already been submitted within the court system, is a potential sale of the home subject to the court? Or is the homeowner still able to fully negotiate the contract and execute it?
Well, I'll answer, and then I'll ask Mike if he wants to pipe in. I would answer it really in two ways. You're not out of time to negotiate. It just becomes a bigger challenge. If you can negotiate before the lender gets into the foreclosure and has hired attorneys, it's easier. Once they've hired, yeah, is it a little harder? Sure. But if they're at the beginning of the lawsuit, you can still negotiate. And kind of as Ryan mentioned, just because you might be a little bit further in does not mean that it's over. There is an opportunity there. The courts are going to, as Ryan mentioned, the courts really want you to stay in your house. The courts do understand that the lender has a right to that house. But if you approach that lender and say, if the attorney walks in and say, Judge, we're trying to work this out, the judge is going to delay that. They're going to give more time because they want people to stay in their houses.
Yep, absolutely.
Well, and
Right.
I think,
Oh,
I
go ahead.
think on that question specifically, how I would answer is you do not need approval from the court to effectuate and finalize a short sale. The process of negotiating that short sale is really done almost 100%, if not 98% at least, outside of the courtroom. In fact, most of the attorneys, Cadillus, Pierce, most of the high volume foreclosure attorneys do not want any part in negotiating a price on a short sale. They tell you pretty much on every one of them I've ever done, just go to the bank and negotiate with them freely. And then what happens is if we come to an agreement with the lender, and that's really in my eyes, that's the only party we're ever negotiating with. If we come to an agreement with the lender, they give us a short sale approval. And it's a written approval that says, you owe us 300,000, we've accepted 210,000, here's the terms. And then we proceed to a closing. And then Cadillus and Associates, whoever the plaintiff's attorney is, after that happens, they will go in and dismiss the foreclosure. In my experience, that's always how it's done. Now, maybe the other attorneys on the panel have done it different where they negotiate with the plaintiff's lawyer, the bank's lawyer, but we're usually just going straight to the bank. And we found that that's probably the most, for us anyway, it's the most efficient way to finalize a short sale.
Thank you.
Yeah,
Oh, go ahead.
if
Ray.
I could just add on that, I think Mike is absolutely right. If you're going to negotiate that, talking to the lender versus litigation, Cadillus or whoever it is definitely the way to go. The one thing that you want to make sure of, though, is when you're talking, there's usually two different groups that don't necessarily talk to each other. So you have the litigators and you have the lender, who's handling the loan that's in default. If you work it out with this one, you got to make sure that they're communicating with this one. The last thing you want to do is pay off, get through a short sale or whatever, and they continue on with the foreclosure. And we have seen that happen. And it's just because they're two different groups. You got to make sure that they're communicating.
Yeah. And just to clarify too, not every foreclosure is a short sale either, right? They may not be upside down on their property.
Correct.
They're just not able to pay, and they're not able to get that money out of the property. So in that case, is the process the same?
Well, if they're not, it's not gonna be a short sale, then I think you're gonna reach out to the plaintiff's attorney for the payoff letter that you normally get from the bank.
Okay.
And that payoff letter is gonna reference, that the case will be dismissed upon payment.
Mm-hmm. Okay, great. Thank you. Okay, so there's so another question. So the chat is blowing up here, guys. Is there a fee that attorneys charge the owner of the distressed property up front? So what's the fee structure look like from an attorney standpoint? And, is it different than a normal real estate transaction?
Well, for us personally, everybody's going to handle this a little bit differently.
Yeah.
These things are, they're
Case by
entirely
case.
different. Yeah. Well, for us, we have a kind of a standard way of doing it, but other attorneys might vary. And so how we always do it is this, and I used to joke with my realtors and just say, if your client doesn't hire me, I must be really bad at this. And here's why. We don't charge the owner a fee, period, ever. If it closes, we don't charge them a fee. If it doesn't close, we don't charge them a fee. And what happens is this, all of this business, all of the short sale business, and there's not many attorneys out there wanting to do short sales, but we're fully staffed. I've got somebody with a law degree that that's pretty much his main objective here. And it still is doing short sales. Believe it or not, we're still doing a few a month, but we don't charge a fee. What happens is if it doesn't close, we're free. I mean, that's just the bottom line. We don't make any money. But in the end, we didn't do our job then. If it doesn't close, then, well, we couldn't help you and I don't want a fee. If it does close, then we'll work out a fee with the bank, just like the real estate commission. We'll go to the bank and say, well, here's the purchase price, and here's all of the things that you need to pay out. Commission, transfer taxes, attorney fees, title fees, etc. The bank then comes back and negotiates it. And for whatever reason, there's oftentimes a large bullseye on the attorney fee that we found, and they'll lower our fee. Generally, they'll pay the realtor 6% commission, though, which is a beautiful thing for the realtors. So always on your short sales, when you're listing them, do them at 6%, whether it's 3 and 3 or keep 3.5 and pay out 2.5. But I digress a little bit. But we don't charge a fee. We incorporate it in with the transaction. And so never on any short sale ever have we actually had a client write us a check outside of closing for our fee. Other attorneys are different. Now, there's one caveat. When we go to court, and we only do that if people wait a little bit too long, right? Or maybe post judgment and sheriff sales pending, when we have to go to court to get the extensions that Ryan Waite was mentioning, there's a fee for that for a couple of reasons. There's court costs involved. So we have to file an appearance, that's $200 or $300. And then we usually charge a $300 fee to prepare and go argue the motion. Well, because that's court work and I don't do a lot of court work and I don't like it. So I'm going to charge you a little bit of money to do it. But aside from going to court, they have a free bite at the apple where they're not paying the realtor, they're not paying the attorney. They know that they could take a chance on doing this with no money out of pocket. And so it really is a no risk thing. The only thing they have to do is be dedicated to providing the paperwork, because there's a lot of it that they need to provide if they're going to try and sell the property.
Great, thank you, Michael. And one last question that so far is, how do you handle a situation in which you have a couple who owns a home and wants to sell, but the other party does not? So one and the party who does not want to sell is unable to buy the other party out and does not have the ability to pay the mortgage.
I'll let Raymond take that one.
Right.
Yeah, like I'm an expert at couples that don't get along, right? You know, there's really only two ways, you know, on these situations. It's either you're going to come to an agreement or you're going to have to force some kind of lawsuit to, you know, to force the other to either partition the property, which, you know, is not really always practical, or to sell it for whatever reason. I mean, you know, you just can't put a gun to their head and tell them to, you know, go ahead and that you want to sell it. One doesn't agree, the other doesn't. You have a dispute. How do you solve a dispute? Either you come to an agreement, or if you can't come to an agreement, you're going to have to take it in front of a judge and let the judge decide, you know, who's right or who's wrong or what course to take on that.
Yeah, it's always good to work that outside of the courtroom though, right? Because it just gets costly when you start involving everybody else. Great.
Yeah,
Okay.
absolutely.
And one other thing, we're getting a lot of questions too that are asking, how do we know about homes in foreclosure early and all that? And what I would say is I'm going to direct you back to your reps on this, because they have a ways of looking and seeing some of these things, homes that are going into default, homes that are late on mortgage, stuff like that. So, you know, and you'll have, if you've been invited and you say, oh, I don't know who my rep is, we're going to send you a list of the reps and their areas and stuff like that, so you can reach out to them. Okay. Scott, go ahead.
Well, I think I'm done with the foreclosure. I think
Okay,
it's
awesome.
good at this point to shift it over to tax sales and Eric. A lot of these issues are similar, but it's a very different process.
Okay, great. So great, Eric, welcome. And why don't we start on the tax sale portion?
Okay, yeah, so as Scott just said, basically this is the same process where you would have, once there's a tax sale, and we'll go over that process, but once there's a tax sale, then it goes into the tax petition filed with the court. It's basically like a foreclosure in that there has to be notice giving, and at the end of the day, there's going to be a court order confirming that everything was done correctly, a deed issued by the court, and the person is then going to lose their property.
So Eric, just to simplify things really quick, a tax sale is I didn't pay my taxes,
Right.
And it goes to sale.
Right. And I'll
Real
go through that.
estate taxes.
Real estate
Yeah, so-
taxes. Yes.
Yes, so let's go through that. So basically, when someone doesn't pay their real estate taxes and they become delinquent, the county that's owed the taxes will put it up for a tax sale. And generally there's three different kinds. There's the normal kind you'll see is just called the annual sale. And that is the sale of any taxes that are delinquent for the most recent year that has been billed and owed. Typically occurs somewhere from 7 to 9 months after the second installment is due, or the only installment if you're in one of those counties where it's just all one payment. And once it goes to sale, that results in a lien on that's owed to the tax purchaser. There's also a forfeiture sale. So if you have your annual sale and nobody buys it, then people can go in and just buy the taxes over the counter. Those are usually properties that are not as desirable, which is why they're not bid on anything that's worth really anything much at all. You're going to have bidders at the sale because you're picking it up for pennies and you can turn around and sell it for, a pretty decent profit. The third kind of tax sale is a scavenger, and that's typically where every couple of years, any parcel that has 2 or more tax years that are delinquent, in the last 20 years, they'll put that property up for a scavenger sale. And these are typically your least desirable properties. They're distressed or abandoned commercial properties, or they're misshapen lots. And they're often sold at these scavenger sales for less than the taxes and fees owed. And so once one of these sales happens and there's a tax purchaser, that tax purchaser will be issued a certificate. And that then means they have a lien on the property. And after the normal period of redemption, which we'll go over in a minute, they're then entitled to file a petition with the court, which is similar to filing a foreclosure complaint on a mortgage, and go through the process to prove up to the court that they have done everything that the statute requires and they're entitled to a tax deed.
Okay, Eric, hold on. So
Sure.
just so we simplify it, which you're making it very simple, but even I want to make it simpler for a guy like me. The incentive for someone to purchase these taxes is twofold in what I'm understanding. One is there's a certain rate of return that they get.
Mhm.
Is that right?
Yeah, that's the primary reason people buy delinquent taxes, is so they can sit on it, earn the interest, and then when it's redeemed, they make a quick profit.
Okay, and when you say earn the interest, what is that interest and who determines it?
I think, well, right now, last time I checked, I think it's in Cook County 18%. Is that,
Okay.
you know that, Scott?
I don't know off the top of my head what the current rate is.
Okay, but it's almost like what inflation is right now, about 18%, right? Even though they're telling us it's 4 or 5. Just kidding, guys. But it's a higher rate of return, right?
Correct.
And there's another thing too that you just mentioned that I don't want to let that slip past people, is that if they make all the notices and do all the work that they're supposed to do according to the statutes, which are very particular, they then have the opportunity for the cost of the taxes owed to actually foreclose on the property. And is that right? Is that the right word? And then take it into ownership for themselves. So
Right.
those are the two motivations for these people in the tax buying game: getting interest, and in some cases, taking ownership of the property. How often, what percentage of the time do people who buy taxes actually wind up with ownership of the property?
I don't have, maybe someone else has a better idea. I don't have ratios or figures. From my background as litigating these things, all I ever saw was the ones that went to court. So to me, it seems like 100%. But I imagine it's. I'm kidding. As far
I'm surprised that it happens a lot.
Well,
and what happens,
Steve,
the institutional buyers, meaning that the LLCs, that the reason they're created is to buy taxes then flip the properties. I mean, they file, I'm just ballparking, they could file 15 to 20 of these things, in a month. And they typically have, the same attorney going in on all of these at the same time. And so when you're in court, you'll see, an attorney step up on behalf of so-and-so LLC and just run through them. And so all from the same tax sale from the same year. But I imagine the majority of tax purchasers are just getting the interest. It's much easier that way. You don't have to go through all of the prove up rigmarole. You just sit on it until it's redeemed and you collect your interest.
Okay. Scott, you were going to say something.
Well, Eric's pretty much hit on it. I think, when you're in this area of business and you're either going to be an investor who's looking at buying these properties as a bulk, or you're just there for that crazy interest rate. You just want to make better than you can make putting your money in the bank. You can buy the taxes and you can make some interest. I think where you see the litigation kind of bubble up is when those tax buyers hit the home run, when they buy taxes for $5,000 and all of a sudden it's a $500,000 property. That's where you see, those are the cases where, hey, okay, I want that property because I can flip that around and I can really make a huge profit. But a lot of times, as Eric said, you have these properties that are not paying taxes, and it's because they're not desirable properties. And the last thing these tax buyers want is title to the property. They'd rather have the interest.
Interesting.
Right.
So a question in our chat is, how many installments would you have to buy to be able to get ownership?
You just have to buy 1 year's worth
1 year of taxes. Amazing.
I've seen just a couple of weeks ago, I was looking at one where the tax purchaser paid a few $100s and is going to get a deed to the property.
And how much is that property? Is that a local property or is that?
No, this was in Southern Illinois. So,
Okay.
I think the property is probably worth $15,000 to $20,000, but still,
Yeah.
that's a big difference. And so, you have to keep in mind that the reason for the statutes that allow for this is because when you got delinquent taxes, you got properties that are not producing for the county, and so there's an incentive for the government to get that revenue rolling again, and to also reinstate otherwise vacant or distressed property and make it a benefit to the community. And so, because of those dual interests, get the money rolling and the property performing and not just be a blight. You have the statutes that allow really a relaxed version of due process, like Scott was talking about with foreclosures. The bar is not very high to get a tax deed. And since you are taking someone's property away for what could only be a few $100s, that's why it's very important that the statutes, lax though they are, have to be followed to the letter. And there's where we have issue when it comes to title insurance, because often they are not, and that can come back and bite you. And so we take a close look at that, because just because the tax purchaser bought it for a few $1,000s and maybe they want insurance for a few $1,000s, eventually this property will be sold, could be for hundreds of thousands of dollars, and now you're going to be asked to insure that. And so that's kind of the tax deed statutes. It's a little bit of a hidden risk that's in there, a little bit even more than foreclosures, because in most cases there's not even a lis pendens filed. And for the real estate agents that may not be familiar with those, normally when you file a lawsuit that is related to property, you have to file of record with the county recorder a document called the lis pendens, which means there is an active lawsuit that is seeking an interest in this property. And so anybody who obtains an interest after that or buys it, whatever the case, is going to be subject to whatever happens in that litigation. With a tax petition, there's usually not a lis pendens. And so you find out about these things when you've got a new property and you've got a listing, and then the title agent is doing a search, and they're going to find, when they're looking at taxes, that there was a tax sale, and that's how these things come up. And so it is a little bit of a hidden risk, and we can go through a little bit of the process here, and you can kind of see how it becomes a risk. So as Scott mentioned, due process, when you go to ask for a tax deed, due process is going to be the big idea, even though it is relaxed. And so after a tax sale, there's a period where the property owner can redeem the taxes. And that means pay what's owed, including, interest and any fees, and you get the property back free and clear. And that is normally what the investor would want. Usually that period is 2 years. So there's quite a bit of time from when you purchase these taxes to where you might be able to go to get a tax deed, or even see the benefit of a redemption if they wait until the last minute to redeem. So this is a little bit of investment that you might have to sit on. So when you get to the end of the redemption period, according to the statutes, in the 3 to 6 month window before the redemption expires, that's when you have a lot of work to do as a tax purchaser. There are several notices that have to go out, similar to what Scott talked about with foreclosure cases, where you have to give notice through a summons to all interested parties. In the tax deed world, there are notices that are prescribed by statute. It's a take notice. It has to provide the information that there was a tax sale. Here's the date. These are the taxes that were purchased. This is the amount. This is the date you have to redeem by. And then here's the date we're going to be in court to prove all of this up. And if you want to fight it, you need to either file something with the court or show up on the day that's in the notice in court and try to make your case. And so, and each of these notices have to go out in a multi-tiered fashion. And so there's one notice that the purchaser has to send out right after the sale, and that goes to the person that's listed as receiving the tax bills, the tax assessee, saying, hey, I've purchased these taxes, and here's how much it was, and here's the redemption date. And then fast forward to the end of that redemption period, in that 3 to 6 month window prior to the expiration of redemption, that's when you have to send out another notice, and it has to be sent out basically twice. The one notice has to be given and filed with the clerk of the court, and the clerk then sends that out to the interested parties. And the same notice has to also be served by the sheriff, or in depending on what county, it could be a process server. And that has to go to the interested parties. And all of the evidence of both of these notices having gone out has to be in the court file. And that is what is used to prove up that you've satisfied the notice provisions of the statutes. And so when we're looking at these things, that's what we concentrate on the most is, was there a complete listing of all interested parties, that be owners, lien holders, any municipalities that are owed money for, cutting the grass or building code violations, anything like that. Or all of those people named in the lawsuit, and did they all receive these notices that they were required to receive? And in cases of the owners, they have to receive both from the clerk of the court and the sheriff. And so we're going to look at that. As I said earlier, the due process is relaxed. One of the ways it's relaxed is, in a normal case, you have to serve all interested parties, no matter where they are. And you have to show that if you can't find them, you have to show that you exercise due diligence in trying to locate them. And you have to file a motion with the court saying, I've done everything I can do, can't find them, here's the evidence, and ask the court to allow you to just publish in a newspaper in lieu of actually serving the documents on whichever party you can't find. In a tax case, all you have to show is that you couldn't find them in the county in which the tax case is pending. That is a very relaxed and easy bar. And yet, we often find that there's no evidence of that diligent inquiry in the court file. And that's one of the big red flags when we're reviewing these things for title insurance. And so if you have an order that for a property that has a tax sale on it, you might see that there's quite a delay when you're working with your title agents and they're trying to work this up. And that delay is often going to be because they've sent the court file to us, they've reviewed it, and we review it. That's kind of our process, is we need to review the entire court file, and they've done it as well. And we're finding that there are deficiencies in the record as to whether or not everyone received all of the notices that they were supposed to receive. There should be green cards in the file evidencing it was sent by the circuit clerk to the proper people. There should be affidavits from the sheriff or the process server saying, I served so-and-so at this address at this time, or I couldn't find them. And if they can't find them under the statute, they have to conduct a diligent inquiry into the whereabouts of that person to try to serve them in the county. And they're supposed to file an affidavit or other evidence with the court showing what they did. And if they've done that, then the sheriff can just drop a green card, certified mail, and it can just go out into the world, and it doesn't matter if it comes back signed or not, as long as they've shown that they have tried to find either the person or the company, whoever it is, and they could not do it. So that's a big thing with tax, and we're very strict about that because, as Scott mentioned with the due process, because it is a lax standard and because you're taking away someone's property for very little money, it's a strict standard that all of these statutory requirements for notice have to be met. And if they're not met, the resulting tax deed is void. And there's really no way around it. And so that's why we're very careful when we look at these things.
Okay, Eric, you just said a
Yeah.
mouthful there. So first off,
Yeah.
I just want to ask if our panelists have any additional commentary on what Eric just talked about. I do have some questions.
I would just mention one thing, and again, maybe Ray's or Eric's experience is different. Generally speaking, if there's a mortgage on the property, those houses generally don't go to tax sale because
That was going to be my question. Thank you, Mike.
well, what I've seen is, right, the tax sale is going to trump a mortgage, and so property goes to tax sale. And correct me if I'm wrong here, Eric, but the mortgage is falling off, and so if a lender's got a $100,000, $200,000, $300,000 mortgage, they're not going to let that happen generally. Sadly, what I've seen, and I haven't seen a ton, I haven't done a lot of tax sale work like Eric has, but what I've seen is generally these tax sales property are either very, very bad properties on, let's just say, the south side of Chicago that not many people are fighting to save, or a great grandmother who doesn't have a mortgage on her property, either doesn't have the means or just kind of forgot to pay a tax bill, and these people are put in a very, very, very bad spot. So generally, when we see tax sales, what I've seen is there's usually not a mortgage on it. So from a listing agent standpoint, as long as the property has value, which most of them do, again, anything you're going to find to DuPage, Will, Kane, most of Cook, those are really easy sales in that you don't have to fight anybody over anything. You just have to get a certificate of redemption for what's due on the taxes. And as long as the property is worth something, the process of being a realtor, listing agent, and seller's attorney on those is much easier than the process of negotiating a short sale is going to take 2, 3, 4, 5 months. But that's my experience. And I don't know, Eric, if you could just comment, is there anything there that I misrepresented? Because I don't want to do that on the panel.
No, absolutely. You're absolutely correct. And you're right. Most properties that go to tax sale they've been abandoned. They're either vacant commercial or they're residential and they've been abandoned for whatever reason. And so that's why you very often do not see evidence of personal service by a sheriff on an owner of residential property in a tax sale, because if they were there, they probably would have paid the taxes, especially when you're talking about a very low dollar value. And again, that's one of the reasons the statute is relaxed and allows you to get by without personal service, as long as you've shown you can't find the person in the county, because otherwise you're never going to get this property performing again. It would be just more difficult than it's worth, given the scenario. And so you're right, it's either it's been abandoned, or we do see quite a bit where either it's an elderly person and maybe they're in a nursing home and the family just wasn't receiving the bills or wasn't on top of it, or the person is deceased and the taxes, doesn't take very long for the taxes to go delinquent and can go to sale. And so in those cases, when I say we're very strict about making sure that there was the proper notice, we want to identify the deficiencies and then evaluate them in the proper context, like you said. So if we find that there's no personal service on an owner and there's no, they couldn't find them for whatever reason, and then we find out, well, the person is deceased and there's, a probate action or something like that, we take all that into account and decide, okay, in this case, the risk is minimal, and so we're going to proceed with going ahead on the title insurance policy side, because even though things weren't done to the letter, there's a valid reason why, and the risk is just not there. And the same with commercial. Yeah.
Okay, Eric. So I just want to acknowledge we're at our stop point, and I want to try to wrap it up. And I have a couple of questions here in the chat. What are the biggest risks in buying tax liens or buying taxes? Are there any risk for the purchaser? You're going to get your interest. You're going to get your taxes paid, right?
Well, that
Yeah.
I'll just
Yeah, go ahead.
interject. You know, the one might be they don't have any interest in redeeming the taxes. So you've paid for the taxes and you have to continue to pay for the taxes. So because you don't want to lose the property to a subsequent purchaser and nobody's interested in the property. That's a risk.
Okay, so that's great.
Right.
So if I buy taxes of a dud property and I want to keep, now I bought them, for me to get my money back, there's not the magical tax fairy that's going to give me the money. I need to either force the owner to buy it, or I need to have a desire to take ownership of the property. Otherwise, I don't get the money I paid for it taxes back to me.
Right. And there's a possibility, and I've seen this a couple times where, let's say you bought the 2015 taxes, and so now you have that lien for that tax year that you purchased, and it's not redeemed, and you decide it's not worth it to go to a tax deed, to go through the whole thing. And so it goes delinquent again, and somebody else buys maybe the 2017 taxes, and they do go to deed. They decide they're going to do that. So they're going to have to name that 2015 purchaser as a necessary party, because they still do have.
Yeah, and they'll get their money back then in that case when they redeem it.
In that case, they would get it back. Yeah.
Okay, Eric, so I just want to follow the timeline of when a guy like you gets involved. So I owe taxes, I didn't pay him, and I own my home free and clear. Someone comes in, buys my taxes, redeems them. As of right now, you're not seeing this, because when you say cases I review and things I look at, there's no reason for you to get involved so far. When do you get involved? Why are you reviewing this? How do you come into play?
So from an underwriting perspective,
yes,
where I would come into play is, I would say 98% of the time, a tax deed has been issued to one of these institutional purchasers. So it's an LLC usually, and now they want to sell it to an actual buyer for actual money. So,
okay,
they
so,
bought it
and
for
this is where our agents that are on the line come into a play here, because if all of a sudden you bring in a buyer in to a property that's owned by an LLC that purchased it in some tax sale, the risk of the buyer buying that property is that they did not follow all of the processes properly. And next thing you know, your buyer is going to be tangled up. So it's the buyer beware on a property that has tax sale issues in it. But all of that is mitigated with a good attorney and a title insurance company that says, I understand all that nonsense. We insure over that. You're good. Now the buyer can rest easy and not have the tax boogeyman pop out of the bushes, 2 years down the road saying, you did that wrong.
Right. It's very unusual for a tax purchaser, especially the LLCs, to get an owner's policy. They hardly ever do that. Where it first comes up is now they're trying to sell it to a third party.
Yeah.
And so in the normal course of your transaction, they're going to ask for an owner's policy. And so the tax case needs to be reviewed to make sure that that tax deed was properly obtained, such that they're giving clear title to the new owner.
Okay, that's great. And a lot of ways you can find that there's preliminary title kind of work that can be done, or lookups and things like that you can definitely work with our reps on. Okay, anything else, Eric, in closing here on tax?
No, I think we covered the main points. I think the only, the end of the process is like the same as foreclosure, where you go to court on the day designated in the notices, and you tell the judge that I followed all of the statutory requirements. Here's the evidence, and the judge will then enter an order instructing the court clerk to issue a deed to either the tax purchaser or their assignee, and then that's the end of the day.
Okay, great. And if someone's interested in buying taxes, how do they find out information about that? Now, we have information about that as well. You can reach out to the reps, but is there any other way that they can get the information?
I think, and I'm not certain where because I don't often look at them, but just the listings of the tax sales, just like the foreclosures, they publish and identify for the public these tax sales, because they also, like the lenders, want to maximize their chance of getting all of the taxes and interest and fees back.
Okay, fantastic. Okay, so I just want to say to Scott and Eric, I want to say thank you. I want to say thank you to Ray. I want to say thank you to Michael. I want to say thank you to Ryan for your contribution here. There's a lot of questions in the chat, so it just shows there's a lot of interest in this. We'll be sending out our panelists information to everybody. We'll be sending out the recording of the webinar to everyone. We'll be sending out a little brief and a little flow chart on how what the process is, so you can get that in your mind, so you can just better serve your the buyers and sellers that you're working with as well. Also, I just want to be clear, even though we had Michael and Ray and Ryan as our panelists, and we're very grateful for that, I want to say that if that our reps, Carmen, Denise, Anya, Dom, Andrew, they all have we have a lot of partner attorneys that are knowledgeable on this. We're very grateful for our panelists, and they're certainly great options. But reach out to your account executive to find the other partners too that we have a great working relationship with and are very knowledgeable on the subject matter we covered today. So with that, do any of our panelists, any of our reps want to say anything just in closing?
Well, I just want to say thanks for having us. We appreciate it. And, I hope everyone, I wish everyone luck in this market, and just, I hope it goes well and it's not as bad as everyone's predicting.
Mm-hmm.
And I appreciate you guys having me on here today. If we could be of any assistance with any potential short sales or just distressed properties, at one point Raymond mentioned, just because a house is in foreclosure doesn't mean it's a short sale, but all the same, if the seller doesn't have any options to make payments, those homes should be sold while they have some equity. So we'd love to help anybody who's got any of those distressed deals.
Thank you. Oh, Denise, you're on mute. I don't know why. Yeah, you're not.
There you go. Maybe just check your volume.
Yeah, the microphone's not coming through. All right, Carmen, you're on the screen now. You have anything, Carmen, you want to say?
No, I just want to say thank you so much. I know I've had a lot of communication, a ton of communication with a ton of you. I see that there are a ton of questions pending. Kind of breaks my heart that we can't get to them, but we only had an hour.
I did try to answer all the questions.
You did. You did amazing.
Yeah.
But exactly like Steve was saying, reach out to us. Reach out to us. We have a lot of information. And like Mike and Jaliri was saying, not only on these kinds of transactions, like we're all saying, we're hoping we don't get too many of these. So we're hoping for regular transactions, right? But in anything that you have, any questions, reach out to your main point of contact, whoever helped register you. There's a lot that we can help answer. Denise, did you ever get your speaker on? Okay.
She was going to say something brilliant, I'm sure.
I know she always does.
Okay, thanks everyone. We appreciate you. Have a great day, and look for our February event coming up, and we'll be announcing that soon. So we appreciate you, and we love serving you guys and your clients. See ya.
Thanks, Steve.